Welcome to WG University, Weber Gallagher series of educational programs. This is our insurance webinar series. I'm Dave Rosenberg from our Pittsburgh office, and I'm presenting with Tim Stalker from the Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com. And you will find copies of this presentation and others under the WG University page, which is in the upper right-hand corner. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Rancosky versus Washington National. Pennsylvania deals with bad faith standards head-on. Let's get started, Jim.
Let's get started. Hello, everyone.
So this Rancosky decision was the first time that the Pennsylvania Supreme Court dealt with issues involving the statutory bad faith, basically since 1990. The bad faith statute, which you can see on the screen, does not define what the standard is for bad faith, what evidence you have to present to establish it. And this left the law up to the courts and to the lawyers to go off in a lot of different directions. With this decision, the Supreme Court tightened the rein and unfortunately tipped their hands that they are going to be a little more insured friendly.
Yes, for those of you who are taking notes, the bad faith statute is 42 Pennsylvania Consolidated Statutes 8371. And you have the gist of the statute in front of you in our first slide, which states, in an action arising under an insurance policy, if the court finds that an insurer has acted in bad faith towards the insured, the court may take all of the following actions: award interest in the amount of the claim from the date of the claim, the date the claim was made by the insured, equal to the prime rate plus 3%.
So the bad faith statute came from questions raised through case law over the years. So if you look at bad faith historically in the state, first, we have the Cowden case, where they did refer to bad faith, but in D'Ambrosia versus Penn National, the court said that there is no tort or trespass action for bad faith. And I would say as a result of that decision, the legislature decided to create this bad faith statute.
So again, the bad faith statute was a direct result of the D'Ambrosio and some early case law, which included Cowden.
There was litigation also on the Unfair Trade Practices Act, but for the most part, since 1990, when the bad faith statute came out, courts tend to dismiss those Unfair Trade Practices Act claims because there is the bad faith statute. So the problem is, since 1990, courts really didn't have much guidance on, at least trial courts, on exactly what the statute, how the statute was defining bad faith. There was no standard for proving that bad faith, and the courts were kind of all over the place. And as a matter of fact, there's a split between state courts and federal courts on how you try bad faith cases. For example, in state court, when it comes to determining bad faith liability under the statute, state courts say that has to be decided by the judge. But in federal court, they take a different position. In those cases, are decided by a jury. So strategically, you had to take that into consideration in determining how you wanted to proceed, whether you wanted to remove it or not. The first case began to define the standard for bad faith is Terlecki, and Terlecki set forth a two-pronged test.
Right. The two-pronged test was first prong in order to establish a bad faith was did the insurer lack a reasonable basis for denying the claim under the policy, and the second prong was did the insurer know, or did it recklessly disregard it, or have a lack of reasonable basis in denying the claim. It was what we felt in defending bad faith claims, a pretty solid basis to defend those claims. I had the responsibility back in the 90s until about 2000 to be in-house. And part of my responsibilities was to manage bad faith litigation for about 15 years nationwide. And we looked at Pennsylvania as not one of those states that worried us with concerning bad faith litigation, so long as we had a reasonable basis for denying a claim and weren't reckless. We were more concerned about other states at that time, like Texas, Wisconsin, California, Florida, and West Virginia.
Put a shameless plug in for whoever we got. Many of us in the Pittsburgh office are licensed in West Virginia and handle West Virginia cases. But believe me, defense lawyers are afraid of that jurisdiction. It is a wild, wild West Virginia. In Terlecki, there was some confusion established, although they set forth the two prongs. They also referenced Black's Law Dictionary definition of bad faith, which in a sense created a third prong. And what that said was, to establish bad faith, you have to prove a dishonest purpose, such as self-interest or ill will. And as a result, a lot of courts applied that as either a third prong or as a kind of gatekeeper test to get to the first prong. Tim, how did you look at this dishonest purpose in analyzed cases when you were in the house in Pennsylvania?
Well, I looked at it as a very that the policyholder would have to show a high degree of ill will, more than mere negligence or recklessness. So I looked at it as a high test for the policyholder in order to collect for bad faith under the policy. And I have to say, being in-house for a number of years and then being outside and handling bad faith cases in Pennsylvania now for about 15 years, I can't recollect one time where we've been hit with bad faith in Pennsylvania. Can't say that about other states, but Pennsylvania has been pretty solid.
There have been a few bad faith awards, but one thing I noticed, and I handled bad faith on a statewide basis, there were really, as far as I can tell, only two pockets in the state with heavy filings of bad faith actions. That'd be the Philadelphia area, where we are now, and up in the Scranton-Wilkes-Barre area. There were very few cases filed in other jurisdictions, and if they were filed, basically the plaintiff's lawyer was just including the bad faith account to kind of I hate to use this word, but trump up the negotiation position, but ultimately they fall by the wayside because of this test. Even
right, just no. In my point of view, again, when I was in house, but even now, as you indicate, many plaintiffs throw in a count for bad faith, and in my view, it has limited value, but it's just part of the process of complaint bringing, if you will, in these jurisdictions. You expect a count for bad faith.
And this whole difficult threshold of proving ill will or self-interest was at the forefront of this trial. In Rancosky, interestingly, this case was tried in Washington County, Pennsylvania, which is western Pennsylvania. It's one county outside of Allegheny County, where Pittsburgh is located. I actually know the judge who handled the case pretty well. She's no longer on the bench, but we don't need to get into why. And also the plaintiff's attorney. I know him. I'll tell you a little known trivia question about him. He may have ultimately won this case, but before I knew my wife, he asked my wife out for a date, and she turned him down. So he doesn't win everything, but his comment on this standard was he thought it was an impossible standard to meet. What happened at the trial level was, now just back up a bit, it was an unusual kind of policy. It's what they refer to as a cancer policy. So this lady had a payroll deduction taken out of her pay every pay period. As a result, if she contracted cancer or some other debilitating illnesses, there would be coverage to assist her with the financial ramifications. And ultimately, there was a dispute that arose. She did contract cancer, and there was an issue about the premiums not being paid. So ultimately, she filed suit, and as you usually see in a bad faith case, there was a count for breach of contract and a count for bad faith. Because we were in state court, it was bifurcated. The breach of contract case was tried before a jury first, and the jury rendered a modest verdict in favor of the plaintiff, Rancosky, and after that, then the bad faith claim went back to the judge, Judge Odell Seneca. Ultimately, what happened was she determined that the plaintiff did not prove a motive of self-interest or ill will and found it in favor of the carrier, and that's where the appellate courts took over.
Right. The argument by the policyholder in the Superior Court was that it was error for the trial court to treat the motive of self-interest or ill will as a third prong for finding bad faith. That the standard should only be used as probative of establishing a second prong of the test. So here they're arguing that you don't have to separately prove self-interest or ill will.
The Superior Court agreed with the plaintiff's Rancosky in this case, and they felt that that there wasn't a third prong. Now, evidence of ill will or self-interest could be used to establish the second prong, but what they found was the trial judge, Judge Odell Seneca, made an error by using that as essentially as the first prong, and that was improper. So they remanded the case back to Washington County for trial purposes, and then the carrier. And why don't we go to the prior slide. So the court held that a motive of self-interest or ill will is probative of the second prong for the test of bad faith, not the first prong. So we can go ahead to the next slide. And by the way, Tim, you're doing an outstanding job with the PowerPoint.
So the result was that as we said, the Superior Court vacated the trial court's judgment regarding the bad faith claims and then remanded it for a new trial.
So the Supreme Court accepted, the carrier appealed, and it was the case was accepted by the Supreme Court. And just September 25th, I believe,
just a month ago. Yeah, just a month ago.
So they did adopt the position of the Superior Court on this case, and I think it's particularly significant because, first of all, the Supreme Court has not spoken on bad faith basically since, at least this issue of bad faith, since the statute came out. And the second issue I think that's important is we've had a shift in the makeup of our Supreme Court over the last 18 months, and people are wondering how that's going to impact the insurance industry in our jurisdiction. And for those of you that know, who are from other jurisdictions, Pennsylvania, all of our judges in Pennsylvania are elected officials, all run on a party basis. And this is one of the reasons why carriers like to move cases to federal court, because of course federal judges are appointed, and the state court judges aren't necessarily, weren't necessarily insurance lawyers or trial lawyers. They are, a lot of them were more involved in politics and that sort of thing. But this goes for our Supreme Court too. The Supreme Court justices are elected officials, and they run on a party line. So you can have shifts depending on which party's dominating the court. So in 2015, there was a shift, and now the makeup of the court is 7 Democrats and 2 Republicans. So pundits were wondering how this might impact decisions. So this Rancosky decision is the first decision made by this newly configured court.
Yeah, I think in summarizing what we have in front of you in the concurrence that Judge Wett wrote, basically you've gotten, as we've indicated, you've gotten rid of the third prong, and you really don't have to now prove self-interest or ill will. It may be an element of the second prong, but you really don't have to prove it now in order to recover bad faith damages. It's not fatal to the claim. So if you read the majority opinion together along with the concurrence, basically the test is not as tough, at least what I believe, prior to this opinion. And so what, as we were discussing, what does this mean going forward? Clear and convincing standard still remains as far as the recovery of bad faith damages. There's been no clarification on punitives. And as we discussed a few moments ago, the court is becoming more policyholder friendly, and motive, malice, and ill will is much less important. And we do believe that although we see bad faith cases filed in Pennsylvania on a regular basis, we believe that the plaintiff's bar will be more inclined to file these cases in Pennsylvania due to their reading of this opinion.
Yeah, I think there's a number of reasons for that. I think the plaintiffs bar looked at the concurrence, and they feel that's an indicator of further erosion of the court's long history of being a carrier-friendly jurisdiction. I mentioned to you, Tim, I had a case when before Justice Wecht was a judge. He was the plaintiff representing himself, so I got a little bit of a flavor of his personal philosophy towards insurance companies. So I definitely am not surprised by him going in that direction. Now, I think the fact that we still have a clear and convincing standard is important, but on the other hand, who is applying that standard? It's going to be applied by the trial judge in state court. So, okay, why might you choose to go to state court as opposed to federal court, where typically the federal court judges, I'm trying to be careful here, Tim, but I will say maybe a little bit more intellectual and a little bit more likely to follow a strong legal argument on summary judgment. The issue is, if you don't succeed with the summary judgment and you're in federal court, the verdict is going to be rendered by a jury with complicated issues. Who knows what numbers they might come up with? And historically, I would say prior to the last year or two, it is very rare to have a runaway verdict on bad faith with a state court judge, although we just saw one for, what, $21 million?
Yeah.
So, my concern now is if the Supreme Court's indicating to the trial court judges that, hey, you can be a little tougher on insurance companies, they may be more likely to find bad faith against the carriers. They might be feeling as if all the standard has been loosened, and they might make bigger awards. So I would be concerned if I was a carrier.
Yeah, and although this is not on the slide, my recommendation to carriers is the following, and it's really concerned claim handling and file maintenance and all of that, is that when you're in a coverage matter, document your files. Also, avoid frivolous comments in the file. Your claim professionals should undertake a proper analysis of the exposure. There should be a methodology or a rationale to what they're offering or not offering on a file. To the extent you need experts, you should retain those experts. And then, again, negotiate in good faith with the other side so that you what your actions in your file look as if and show that you've taken reasonable steps to handle the claim. This is basically the same, I'm sure, same guidelines that everyone has within their organization. But just make sure you document your file so that you don't expose yourself or your company to bad faith allegations and exposures.
I think anything you put in, you write in a claims file, when you write it, you should be thinking, what if I'm cross-examined on this comment I put in there? If you just stop and think before you put it down, you should be in good shape. Tim, what do you think about choosing whether to remove to federal court or proceed in state court based upon this new decision?
Well, it would depend upon where in Pennsylvania we are, but you know, I kind of would prefer a judge to make the determination as far as whether there is bad faith or not versus a jury. But again, it depends upon where you are in the state.
Yeah, that's a good point. You've probably heard in politics, people say that Pennsylvania's Pittsburgh and Philadelphia with Kentucky in between. And from the perspective of trying cases, Philadelphia is very liberal. There can be some big verdicts there, but we also have a couple other pockets. The big verdicts out of the Scranton-Wilkes-Barre area, which is north of Philadelphia. Allegheny County, where Pittsburgh is located, there have been some very big verdicts lately. And up in Erie, which is in the northwest corner, there have been verdicts. But for the rest of the state's pretty rural and is fairly conservative. Although awarded this $21 million award, that was not in Philadelphia, Pittsburgh, or Scranton, was it?
No, it was in Berks County, which is right outside of Philadelphia, kind of the Reading, Allentown area. You know.
So really, when you're handling a case, it's not just a matter of the state, and it's not just a matter of the county. You have to know judges in that county as well, right?
You do. And we have the same issues in New York. There's some issues I went in front of the federal bench, and others not. And sometimes when we're dealing with diversity, meaning a question that we can get into the federal courts, then sometimes you have options and you can pick and select.
Do you feel that we get more consistency on the federal bench than we do in the state bench?
I believe so.
I agree with you. So I would think after this ruling, the scales are tipping a little bit more towards removing cases and placing them in federal court, even though you do have the risk of a jury verdict. And remember, the jury pool in federal court is wider than it would be for a county. So it softens the risk a little bit. On the other hand, the juries are smaller, so one bad juror can really skew things more than it would in a state court. So, those are just certain considerations to have.
And then strategically, as we mentioned earlier, you can move to bifurcate the bad faith claim aspect of the claim from the, let's say, the case in chief. You can also, following discovery, make a motion for summary judgment in an effort to eliminate the bad faith claim. So just a couple of procedural tools.
That point you raised about filing a summary judgment in state court, since the judge is rendering the decision on bad faith, I feel that they're less likely to grant summary judgment because it's going to wind up in her or his lap anyway. Whereas in federal court, I think that the federal judges will take a harder look at the legal issues and applying those legal issues to facts, the uncontroverted facts in summary judgment.
No, I agree with that. I do. But again, it is a tool, if you will, to get to eliminate the bad faith exposure and really get to the core of the case, which is is there coverage? If not, the reasons why, and minimize or eliminate the bad faith exposure.
Tim, do you think that there will be an uptick in filings across the state of the bad faith actions?
Well, putting my old in-house hat on, I'm absolutely certain there'll be more filings, probably for the next year or two, and then it'll get back to normal.
You know, Tim, maybe we both should have put on your in-house hats to cut the glare down in this room.
That's for sure. That's for sure.
Well, I don't know if we have any questions from the audience, but if anybody has a question, type it in. We'd be happy to answer. Having no questions, I want to thank you for attending our webinar, Rancosky versus Washington National. Pennsylvania deals with bad faith standards head on. You can learn more about this program and all other Weber Gallagher events at www.wg.com/WG-university. This program will be available on our website along with all of our other programs. And if you have any questions for me or for Tim, I think we have one more slide. And feel free to call either of us or email us. Tim and I work closely together, and we're on opposite ends of the state. But you get a lot of years of experience between the two of us.
More than I want to admit.
I don't want to admit it either, but I do remember it.
Thanks, everyone. Thank you very much.